Welcome to Your Decision 2018. Today's debate is on Amendment 74, providing compensation for takings of property by government. My four guests include two proponents of the measure, and I want to thank you for being here. Marc Arnusch, who is a farmer from, really, I'd say, southeastern Weld County, is that correct?
That's correct.
And Patti Kurgan, the owner of Astro Logistics, and that's your company as well?
Yes.
Thank you for being here, Patti. Debbie Ortega. Debbie, great to have you back on the show again.
Good to be here.
From Denver City Council. And our House Majority Leader, Casey Becker. Casey, great to see you.
Thanks for having us, Aaron.
You're welcome. So let's talk a little bit, and maybe, Marc, why don't you start off with what 74 proposes to do so our viewers know what we're talking about.
Amendment 74 is just a simple few words put into the state's constitution that would allow property owners to seek a avenue legally to seek the just compensation for their property when government overreaches, when the diminishment of their land takes place, and they have a case that they can take before the courts.
Okay, Patti, why do you think this is needed today? And don't we already have provisions in our Constitution to compensate property owners when government entities seek to take their property?
Yes, there is just compensation if your property, your private property, is taken or damaged. This amendment will make it where you will get fair market value for any damage or taking away. This is very important. Like you said, it is in the Constitution. And I am a member of the National Federation of Independent Business, and that's who I'm representing today. And for business owners, we need continuity. We need to make sure that things are stable. So it's very important to us that we have a true understanding of private property, what is ours, and what our fair market value is, if there are any damages or takeover.
All right, Debbie, why do you think this is a bad idea?
I think it's a bad idea because the language is written so broadly. There are no real guardrails around what this really applies to. And my concern is that the kind of day-to-day business that we do in local government, issuing permits, licenses, rezonings, you name it, anybody can use this provision to come forward and say their property has been damaged and they should be entitled to just compensation, which is outside the lines of when you normally use eminent domain to take a property.
So with eminent domain or condemnation in the case of physically taking a property, there's a process that addresses how much the property owner gets. How does this proposal change that?
It changes it in that it goes way beyond that language. It goes way beyond your typical local government acquiring a property for a public good. This says any policy, any program, any rezoning, you name it, that local government does on a day-to-day basis is subject to being challenged. And I think it gridlocks the work that we do.
And it's not just local government, it's state government. And because it is only 6 words, it really doesn't give direction to anyone about how it should be interpreted. Is there a de minimis amount? No, not specified. What is the process to have one of these complaints go forward? Not specified. Is it only prospective or is it also retroactive for existing regulations? Nothing there. So if this is enacted, there is going to be such a logjam in the courts. It's going to be a huge burden on our courts. It's going to drag everyday people who had no idea that this was coming into court constantly. And hey, I'm a lawyer. That's a good business to be in if this gets enacted. But I don't think that's actually what voters want. And to be clear, it actually can override voters' intent. So for instance, in the city of Boulder, we have a height limit that voters passed at the ballot. But it says any government action that decreases any property value. So if someone says, well, gosh, your height limit now inhibits my ability to develop a 10-story building, and the government owes me because of that, that has overridden what local decision-making has happened a long time ago, and someone can make a claim against government for that. So you get tied up in courts, you can potentially override the will of voters, there's a lot of uncertainty, and it's very, very broad.
All right, yeah, Mark, please.
I think the thing that's being left out in that whole is kind of the sky is falling approach is that that individual has to make that claim before the courts. They can't just say because a building is taller that that's diminished the value of their property.
However,
I just can't understand how a takings isn't a takings until 90% of the value of that property is diminished.
All right, now hold on. Explain, when you use the 90% number, what are you referencing?
The courts have been very clear that in the past when a taking is to occur, that it must meet a litmus test, that the value of that property has to be extinguished to the point where it's almost de minimis in value. And typically that number lands right around 90%.
So give me an example of what that means.
So that means that if I'm a farmer, and let's speak in acres terms, if I have 10 acres of property, and because of a rule or a regulation that changes the fair market value of my property, that they would essentially have to take 9 or 9.5 acres of my property value before I have a claim against the government.
So you're
That's
saying
wrong.
you're saying if your property is worth, your 10 acres are worth $100,000, that you don't have a claim if a government entity or a government-approved entity takes $89,000 out of the $100,000 of value.
That's
it has
correct.
to be 90% or over 90%.
Yes, that is
That's
correct.
what this
And
is intended to fix. This is a total overreaction to that, because now even the smallest claim can be brought. So you can say, and it's not just real property, right? It's any type of property. It's personal property that can be a business license. Any government action that even it has the slightest impact to value, any cost to you, you can now say, sorry, you have to pay for that yourself, or you have to not enforce that. So there are a lot of things.
When you say pay for it yourself, you're talking about that government or that entity who made that change paying for yourself. Let me clarify one thing. So one of the things KC said was she was referencing the idea that an existing if you have a property and there's an existing regulation, set of zoning codes or whatever, and you want to do something with your property after this passes, KC is saying that the owner could make a claim saying, well, now I want to do this, but your previous law prevents me from doing this. My sense is that's probably not correct. My intuition is that that doesn't make sense, but is the way this is written such that that interpretation could be made? And I'd like you to address that.
My understanding is that the rules and the regulations that are now in place stand. So it's really what is going forward.
That's not
And
what the
I
language
looked-
says. There's no restriction in the language because of that. So that's something that would have to be litigated and decided by courts.
And you talk about litigation, speaking as a small business owner, we don't have a lot of money. So we're not going to pursue a trial unless we are 100% certain that we're going to win because of the costs associated with that.
All right, I want to talk about that, but we're going to take a break, and then we're going to come back to you, Debbie, because you need to have a chance to speak. So we'll be back with our panel on Amendment 74 in just a moment.
For information on how to help promote civil and mutually respectful discourse and support expansion of the distribution of our programs, please email info@harbertv.com.
The Rex Howell Broadcaster of the Year Award recognizes an individual who, through leadership, skill, and dedication, is advancing the broadcast industry in our state and our nation. Tonight, we honor Aaron Harber. Aaron has worked extensively in the media as a host, producer, political and economic commentator, and columnist. Today, the Aaron Harber Show is the focus of his media involvement. Aaron, it is a privilege to present you with the Rex Howell Broadcaster of the Year Award. Congratulations.
Just make journalism great again.
I'm Aaron Harber, host of the Aaron Harber Show. Find us on Facebook to get all the latest updates, see behind-the-scene photos, and make comments and ask me questions. You can see episodes before their TV broadcast, so like the show today.
The Aaron Harber Show may be viewed 24/7 at no charge from any location in the world at harbortv.com.
Welcome back to the show. We are discussing Amendment 74 about compensating property owners for takings by and reduction in value by government and pseudo-government or quasi-government entities. Debbie, I know you didn't have a chance to respond before, so please.
So I just want to add that, you know, as part of the day-to-day business that local government does, we license liquor establishments. We provide licenses to marijuana establishments. If anybody feels like their property has been damaged because of those or any number of other similar types of licenses, permits that are issued by the city of Denver, they can come forward and file a lawsuit against the city. But the important thing here is it will be people who have the means to do that. So there will be a disparity in terms of folks who can't afford and don't have the means to hire an attorney and bring a case forward. So I'm very concerned about the inequity that this creates as well.
So let me, and I know this opens up a kind of a different set of claims, but in that vein, for example, when it comes to condemnation, if a government or quasi or pseudo-government entity comes, and in Colorado, government entities in certain respects can grant essentially what are private organizations such as special districts, the right to condemn property, why not address those kinds of issues and for example, limit condemnation powers to only entities that are composed of elected officials, so there is some type of accountability, which seems to be a concern of yours. Your concern, I think, really resonates, which is when a government entity, which has often unlimited legal resources, comes to someone, and I know cases where property of senior citizens on small farms where they had to face condemnation actions, they can't afford, just like you said, they can't afford to hire attorneys. Under current law, KC, you have to, if an offer is made to you and your property is taken, you have to, if you go to court, you have to win 130% of the offer of the government entity. So you have to win more than what they offered in order to get your attorney's fees paid. Why should a senior citizen or a couple in retirement on a little farm have to pay any of their attorney's fees? If a government entity says, we're taking your property, shouldn't those people have their attorney's fees covered?
You know, attorney's fees is a totally different subject than what we're talking about now, and we could go down that path. What we're talking about right now is proliferation of litigation, or not even that. You can have the threat of litigation, and it's going to put government in the position where it cannot act. You're going to have regulatory chill. Local and state government is going to be in the situation where you're damned if you do, damned if you don't, because you don't know who's going to bring the lawsuit. So if there's a rezoning, one property owner could say that rezoning affects me, and the property owner on the other side says, no, it can affect me. So you're essentially forcing the status quo on everything, which actually isn't good for anyone. It's not good for economic development. Marijuana wants to come in, and the neighborhood says that's going to lower my property value, but the marijuana industry might say, well, I own that lot, and if you don't let me come in, it affects me. So how can you make a decision on anything? You don't actually have to bring litigation to stall anything from happening. You can threaten it, but let's say you actually bring the litigation.
Hold on.
Then you're just forced into a situation.
I want to give Marc a chance to
having
talk. Casey, I want to give Marc a chance to talk too. So I'm going to ask you all to, we don't have that much time, I want to ask you all to keep your answers short so everybody gets to participate. So here's the language in section 15. Taking property for public use. Compensation, how ascertained. Private property shall not be taken or damaged or, in the new languages, reduced in fair market value by government law or regulation and then the rest stands as it is now, for public or private use without just compensation. So, Mark, that does really seem to just open up a lot of possibilities, as Casey and Debbie have argued. So please address that. And what else you were going to say?
Keep in mind, though, too, that the Constitution is the guiding principles for the courts and for the state legislature. We need that language brought in there to encompass a lot of the takings that could happen when government overreaches. But to Casey's point, I think this also drives towards better government, to involve those stakeholders that have those claims of, look, you've pulled the carpet out from underneath my investment back expectation. I bought this property with the expectation I'd be able to develop it in this manner, but you've pulled the carpet out from underneath me. And when you've done that, you've changed the value of my property. That's the avenue that those individuals need to seek when looking for that just compensation. And I would also tell you, because of the costs of litigation, that bar's pretty high. So before you're going to go to litigation, you're not going to litigate over $5,000 and $6,000 claims. You're going to litigate over significant property value, challenges.
All right, Patti, what did you want to add?
Well, I'm just going to go back to the rules and regulations on small business owners, and they become quite burdensome. So if a new rule or regulation directly impacts a private property owner and it devalues their property and they feel like they are justified, I believe that they should have the right to pursue. And it also goes back to your point when you're saying many of the people who are setting these rules and regulations are on elected officials. So we need to hold them accountable. So I think it's extremely important.
Debbie, I'm sorry, go ahead. I don't mean to keep coming to you last.
No, that's fine. I think, part of what we do is look at addressing public health and safety in many of the policies and practices that are brought forward. And if we can't even do that, you don't govern by bringing everything to a screeching halt. And I believe that's exactly what this amendment will do. We're either going to be tied up in the courts, and the courts will, decide what sets precedents, right?
So in that vein, so for example, Mark and Patti, I'd be really interested. So let's say the House of Representatives, where Casey is, or Denver City Council passes a new regulation in regard to sanitation, requiring a higher level of safety for any kind of new construction of residences, commercial buildings, or whatever, or farming operations, whatever the case may be, which is going to cost you a significant amount of money.
That's the difference. You're talking about costs, we're talking about value. And those are left unchanged in Amendment 74. Just because the costs go up doesn't mean that your property value has changed.
Well, that's not necessarily true. I would argue that if my property is worth X dollars, and suddenly, let's say my property is worth $1 million, and let's say a regulation is passed which is going to cost me $100,000 to implement. In my attitude, the value of that property may have gone down $100,000. Is my analysis wrong? And if so, tell me why.
I think your analysis is wrong. Just because the costs
You're not
go
the
up,
first person to tell me that, Mark, by the way.
just because costs go up doesn't mean that your value has changed. And that would be a very, very difficult.
But certainly if your costs do go up, it can mean your valuation has changed.
Well,
But
it's an
it could also
expense
make
of
your value
business.
go up, too.
And tell me how my value just went up when I'm forced to spend $100,000.
Because now you're in an environment that costs more to do business, and that could be something that's attractive to someone else looking to come in and take over that location.
But there's nothing in this provision that says if it increases your property value, that any of that comes back to local government or to state government either.
That's why it's a takings provision, not a givings.
Okay, we're going to take a quick break. We'll be right back for our final segment with our panelists.
For information on how to help promote civil and mutually respectful discourse and support expansion of the distribution of our programs, please email info@harbertv.com.
I'm Aaron Harber, host of The Aaron Harber Show. You can follow the show on Twitter for instant notification of new episodes, live event invitations, outtakes, and behind-the-scene photos. And tweet us your topic and guest suggestions today. I'm Aaron Harber, host of The Aaron Harber Show. I very much would like to hear from you about the program, so please send me an email with your thoughts. You can suggest what topics I should cover, what guests I should invite to be on the show, or even what specific questions you would like me to ask. This is your program, so send your suggestions to aaron@harbertv.com. I promise to personally read every one, so email me today. And most of all, thanks for watching. I'm Aaron Harber, host of The Aaron Harber Show. Find us on Facebook to get all the latest updates, see behind-the-scene photos, and make comments and ask me questions. You can see episodes before their TV broadcast, so like the show today.
Join me and watch The Aaron Harber Show.
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 I'm Reverend Jesse Jackson. Watch The Aaron Harber Show and keep hope alive.
The Aaron Harber Show may be viewed 24/7 at no charge from any location in the world at harbertv.com.
Welcome back to the show. This is our final segment on Amendment 74. So, Mark and Patti, I'd be really interested to know, is there a broader definition of takings that we could use or that we should have, which addresses your concern about overreach, but isn't quite as open-ended as this one seems to be? Has that been considered?
Well, I would tell you, I think that's part of the reason why the language was designed as it was. It is broad, because there's a lot of times, potentially in the future, where an individual may feel that they have a takings claim at hand. But if we have too narrow of a prescriptive language, we have an arbitrary formula that makes its way into the Constitution, I think we could be putting landowners at risk. That's why it is designed that broad. And I'll also tell you another story. The Colorado Farm Bureau brought this measure forward. And our organization is embarking on about a 100-year history. This language has been in our 100-year history policy book for a long time, that if and when government overreaches and changes the value of private property, they want to seek just compensation. It just makes sense.
All right, you said the Colorado Farm Bureau brought this forward. My understanding, you should correct me if I'm wrong, is that this has been to date something like a $4 or $5 million effort in terms of getting signatures collected, getting this on the ballot. I think you submitted over 200,000 signatures, which is a very impressive feat. How much money did the Colorado Farm Bureau on its own put into this? Because my understanding is my friends in the oil and gas industry really funded almost all of this. Correct me if I'm wrong.
The oil and gas industry certainly helped out considerably. But
to what extent?
I can't give you that number right off the top of my head.
What did the Farm Bureau put in?
We put in a lot of sweat and equity.
How much cash?
I can't give you that number off the top of my head.
Ballpark.
I won't answer that. But what we did.
So you don't. Okay. So you're part of the Farm Bureau.
I am.
$4 million was spent, as far as we know, and you have no idea if you spent $10,000 or $25,000 or $100,000.
We spent considerable amount of time and effort and staff time.
I'm talking about cash.
We also have a non-cash value in this.
I'm not asking about non-cash. So you're telling me you have no idea.
I can't give you an absolute
Do you know if the
number.
Colorado Farm Bureau put in any cash?
Yes, we did put in some cash in that effort. That number I can't give you, Aaron. I just can't.
And why not?
Because we put in so much sweat equity and we put in a lot of time and effort of staff and farmers gaining these signatures in the countryside and around the Front Range. To give you a number, I can't give that to you right off the top of my head.
Well, I can tell you that one of the entities that's filed with the Secretary of State to support this measure has raised $26 million, and it's almost all of it from oil and gas.
And what entity is that?
Protect Colorado.
Okay, but Protect Colorado is also fighting 112. So, I'm not going to say that they've spent $26 million on this effort. But one of the things I'm big on, and I don't care what side you are on, is disclosure and full disclosure.
Transparency.
And I think the citizens of Colorado deserve to know who's backing amendments. And if most or all of that $4 million came from the oil and gas industry, and it's their right to do it, I think Colorado citizens have a right to know where that money came from. And the fact that you're with the Farm Bureau, Mark, and you don't know how much cash you've all put in is beyond astounding.
We're still putting in money to this date. That number's not finalized yet, and we will continue to put money in.
Right.
And I'll be more than happy to get you that number.
But just like a bank balance, you may be writing checks, but at any given time, you know how much is in your account. I don't buy that. I don't buy that.
I'll get you that number.
And in the interest of full disclosure, when you look at where this measure has been proposed, or in some instances passed in other states, it is much more narrow. It has been repealed. And in Oregon, which is the one that's most similar to Colorado's, it led to over $19 billion in claims against local and state government in the first couple years.
Right, but that wasn't $19 billion in claims that were paid by the state, number one. So I don't want to mislead.
Right, because voters actually...
No, because those claims were adjudicated, and approximately, what, $4.7 billion was paid out?
A lot of them were not adjudicated because the litigation ended when the citizens of Oregon actually repealed the measure.
Okay, my understanding is that was 37. The follow-up was a modification, number 49 in Oregon. It wasn't a full repeal. They modified it, but severely reduced the ability to make claims. So I think Oregon citizens said, hey, we need to do something. They sent that message. And when they found out how much it cost, they decided, well, we still want to do something, but not quite that much. So I think the message here, though, is that we need to do something. And that there's clearly, I think, what you hear from Mark and Patti, there's a sense on the part of a lot of people that government has extraordinary power and often does overreach. So go ahead,
I'd
Debbie.
like to just talk about, various projects that the city of Denver has been involved in, from the convention center to the airport to any number of big projects. And what we have done is use the Uniform Relocation Act as a guide, and property owners are allowed to come and get a second appraisal, and they look at the difference between the two of those.
Do you pay for that appraisal?
I don't know, to be honest.
Okay, well, that's again, what I think in terms of government power and overreach, you got to give the little guy and gal a fair shake. And if you're going to make a change, if you're going to acquire property, if you're going to greatly impact property, the little guys and gals should have their costs covered because they didn't ask for this.
And we cover relocation costs, we cover
right, and there's
some
debate
of the business
about
costs.
Right, but there's debate about how much is enough. So I guess and what really resonates, I think, is this 90% figure that you don't have a real claim until there's a taking equal to 90% or more of your property. That's such an extraordinarily high bar.
So let's clarify that.
Okay.
Aaron, I want to thank you for that because NFIB, that's who we represent, is the little guy and the little girl. And we're not, extremely wealthy. And so this gives us an avenue if we are economically damaged. And it's very important that you know that it's the barbers that are members and the drywallers and the bricklayers and the plumbers. It's not the oil and gas. We're the little guys, and we're very concerned about how we are protected with our private property rights.
Sure, but the oil and gas folks have billions of dollars potentially at risk. So this is a good investment for them. And
right, but there's lots of livelihoods,
and their mineral rights
though.
are property rights.
Right. So, okay, we have 1 minute left. Casey, give me a quick comment. Go ahead, please.
You just put me on the spot.
I'm sorry. Well, what did you want to respond to? And we'll try to do a little extra bit.
I think people are confusing eminent domain versus regulatory takings, right? So even the smallest occupation of property where the government's actually taking it, it doesn't matter how big or small it is, they have to pay just compensation, which is fair market value. When you're talking about regulations that burden a business, that's the regulatory takings. And that regulatory takings has to go pretty far before the government has to pay for that. And because the reason
So I think
for
their
that,
argument is that the bar for that is just set way too high. And this is a response to government setting that bar unfairly high and making it expensive for little guys and gals to take on the government.
well, if this is a response to that, it swings way too far to the other side.
Okay, well,
Government is in the business of doing what is in the public interest, what is putting public good over private benefit. And this reverses that by making private benefit over public good.
But government decisions aren't always correct. They're
Sure.
not always fair.
And that's
wait a
where you
minute.
get to elect people.
I'm sorry. And they're not always right. And so the question is, how do we protect the little guy and the big guy? So, Casey, Debbie, Patti, and Mark, thank you very much for joining me today. This is the end of our show on Amendment 74. I'm Aaron Harber. Thanks for watching.
Please contact us. We want to hear from you. and thanks for watching.